seated. So our policy in the courtroom is if you are vaccinated, you're free to take off your mask. You're free to keep it on if you want to. All right, we just have one case on the docket today, Facebook versus Jane Doe. If I could have appearances for the record.
Your Honor, Kelly Sandhill for Facebook.
Jeff Richter, Bradley, Jane Doe, along with Andy McAdams.
All right, are y'all going to split time or?
Your Honor, I've been on it today.
All right, thank you. And are you going to save any time for rebuttal?
5 minutes, please, Your Honor.
All right. I forgot to check to see if we were broadcasting. If not, we're not, or we are. Do you know? Well, we'll just go ahead. Courtroom is open. If we're broadcasting, great. If we're not, we're not. Go ahead.
Thank you, Your Honors. Good afternoon, and may it please the Court. I am prepared today to discuss the 5 questions that the Court has said it would like covered in argument this afternoon, but I'd like to begin by briefly framing the issue that is before the Court. The specific jurisdiction question in this case can be answered in 3 steps. First, the Court has to understand the basis of the Chapter 98 claim that is the only claim remaining in this case. What is it that Facebook is alleged to have done wrong? Second, the Court has to isolate Facebook's purposeful contacts with the state of Texas in 2012 at the time of the claimed injury. And third, the Court has to test the link between those two to determine if the actionable conduct that underlies the Chapter 98 claim arises from or bears a strong relationship to the plaintiff's Chapter 98 claim. Here, it does not. And I apologize, I misstated that. The test is whether the actionable conduct that underlies the Chapter 98 claim arises from or bears a strong relation to Facebook's purposeful contacts in the state of Texas. Here, it does not. The plaintiff does not allege that Facebook violated Chapter 98 through anything that it did in Texas. And there is no relationship, much less a strong one, between Facebook's purposeful contacts with the state of Texas in 2012 and the Chapter 98 claim. Turning to the Court's first question.
Well, but that's based on your argument that you didn't act in Texas because your safety people are in California.
Your Honor, yes.
Okay.
The actionable conduct in this case, as best we can ascertain it from the plaintiff's petition, is associated with decision-making at the corporate level that the plaintiff alleges allowed a criminal trafficker to communicate with her. And the record demonstrates that decisions on that issue at the corporate level were made by senior leadership located outside of the state of Texas. So turning to your first question, which is...
But that's basically where the design of Facebook happened, in California, is what your argument is.
My argument is, well, Facebook's not a product, so I hesitate to use the term design, but certainly my argument is...
Your own CEO said Facebook's a product.
And our position is that the use of the term product by laypersons does not convert something to a product in the legal context of that word. Whether something is a product is a question of law. So the Court's first question that it has submitted to the parties is, does the Ford Motor case's reasoning apply here? And the arises from or bears a strong relationship test that the United States Supreme Court used in Ford Motor absolutely applies to this case. That's not a new test. It's been around for decades in the context of specific jurisdiction. I also would point out that footnote 4 of the Ford Motor decision is instructive in this case, because there, as the Supreme Court did in Walden versus Fiore, the Court recognizes that websites present unique issues in the personal jurisdiction context. And that is why, as noted in our briefs, courts across the nation have held that the mere accessibility of a globally accessible website or social media platform is not a purposeful contact with a forum.
What social media platform do you have a case on?
Oh, we've cited a number of cases in our briefing, Your Honor.
Post forward.
Post forward?
Yes.
I think the Gullen case is post forward. I believe the Gullen case is
Okay.
post forward, Your Honor. I'll also point out the Huffington Post case, while not a social media platform, or I suppose you could, well, I'm not going to define the limits of social media platform because I'm not sure I know them, but I will point the court to the Huffington Post decision out of the Fifth Circuit that came out in December, I want to say December 23rd of 2021. So a very recent decision acknowledging that the accessibility of a website in a forum is not a purposeful contact.
But this is not just a website. You would agree with that, right? I mean, Facebook gathers data, sells data to third-party vendors. This is not just a website.
So Facebook does not sell data to third-party vendors. That's not accurate. I know that's said in some of the pleadings in this case, but that is not accurate. Facebook is a website, facebook.com, and it...
we have some allegations by Doe that you did not deny, including Facebook profits off advertisements directed towards minors in Texas on its platform.
And Your Honor, I realize that this may be an issue of semantics, but it matters. Facebook doesn't buy or sell its users' data. What Facebook does is where users have chosen and elected to share their information with Facebook, Facebook offers third-party advertisers, and this is not an uncommon practice on the internet. Facebook offers third-party advertisers the opportunity to serve ads to those users on the Facebook platform. So say Facebook is not selling data, it's offering space to advertisers.
But it's selling space based on data collected. So if I start looking at one item on my Facebook page, before I know it, there'll be eight other similar items being advertised to me.
If you have chosen to share your information with Facebook, then yes, that information can be utilized to ensure that the ads you are receiving from third parties are ads that you might want to see. And let me be clear that the third-party advertiser chooses the audience for their ads. Facebook does not.
But based on data you give them is how they choose the ad.
Again, it's a little bit semantics, but Facebook does not give them user data. Privacy of users is a very important issue to Facebook, and it does not give the data, but the data can be utilized.
So the ad goes to you, and then you send it to the appropriate users. Is that the distinction
right.
you're making?
What the distinction I'm making is that Facebook does not provide information on its users to some outside third party.
Gotcha.
It keeps the privacy of that information protected, and that's all covered on Facebook's website. Frankly, it has extensive details about the way the ads process works and the privacy of user information associated with that process.
Has that changed over the years? You talked about 2012 contacts. Do we have to look solely at 2012 statements by Facebook?
Your Honor, I'm not, to be honest.
Or is a specific jurisdiction based on when you're sued?
No. So specific jurisdiction is based on the time of the injury. General jurisdiction is based on purposeful contacts of the defendants at the time the lawsuit was filed.
Okay. So, but you mentioned in your opening 2012. Is that?
Yes, because 2012 is the time of the alleged injury
Okay.
in this petition.
So my question to you is, we have a lot of Facebook terms in the record, is it your position that we can only look at the 2012 terms?
To the extent, I'm not sure that the Facebook terms would be relevant to any issue in the case, but to the extent you determined that they were, yes, 2012 is the only relevant period for assessing specific Facebook's contacts with Texas in this case. And so turning back to that question of whether Ford Motor applies here, the longstanding test of arises from or strong relationship with the purposeful contacts applies, and footnote 4 gives us insight as to the Supreme Court's view on the accessibility of websites and how that plays into personal jurisdiction. But the application of the test applied in Ford Motor results in a very different outcome here. And that's because the plaintiff's Chapter 98 claim, as we talked about, doesn't allege that Facebook did anything in Texas. There's no overt act by which she claims Facebook violated Chapter 98 that is identified as occurring in Texas. And unlike in Ford, Facebook's limited, and I stress limited, purposeful contacts with Texas in 2012 do not bear any relationship, much less a strong one, to plaintiff's Chapter 98 claim. And as I move to question 2, I'll explain why that is. Now, in question 2, the court identifies 3 allegations and asks whether those same allegations were made against Ford Motor Company in the Ford case. And answering this question requires a 2-step analysis. So first, we need to talk about whether those allegations even represent purposeful contacts by Facebook with Texas.
Well, how about if you just answer the question first, because you are out of time. I don't mind giving you some more time, but just answer the question before you reframe it.
Sure. So the contacts that are asserted in those 3 categories that you have identified in this question are not purposeful contacts by Facebook with Texas. And the reason for that is, first of all, the providing of significant...
Okay, but those are the same things that were in Ford. That's the question.
Sure.
Okay.
They
Perfect.
are the same things that were in Ford to some degree. Ford had a lot more. I think Justice Kagan used the phrase a veritable truckload of purposeful contacts with the forum. And the very important part, if I may, I know I'm out of time, but if I can just touch on the why those contacts demonstrated a strong relationship in Ford, but even if the court were to consider them purposeful here, which they're not, they don't show a relationship here. The reason for that is in Ford, what was going on was those contacts demonstrated an extensive system that Ford had established in the forum states, there were 2 cases combined, so in the forum states, to sell the very same models of vehicles that the plaintiffs alleged had harmed them. So what was going on was that was an extensive system for selling the very same vehicles in the forum state that mirrored the system for selling those allegedly defective vehicles in the state where the actionable conduct happened. So since the selling of the defective vehicles was happening in the forum state just the same as it was happening in the state where the actionable conduct occurred.
Well, there's no difference between Facebook in California and Facebook in Texas.
There's absolutely a difference, Your Honor, and that's the key.
In terms of how the product is sold?
The question before you is a chapter...
Which is the question in Ford, not the design, but how the product was sold.
And this isn't a product liability case. That claim has been dismissed.
I understand your point on that.
Okay. And so, in terms of the difference between Texas and California that matter here, this is a Chapter 98 allegation, a statutory claim that requires proof that Facebook knowingly benefited from participating in a venture to traffic the plaintiff. And the Texas Supreme Court has said that requires an overt act by Facebook in furtherance of the trafficking venture. And what
Doesn't Facebook connect users of Facebook with each other?
So this is really your question 3. Facebook allows users to connect with others, and the user ultimately decides who they want to connect with.
And doesn't Facebook also make suggestions as to various
there's a
users and
feature-
who should connect?
Yes, I'm sorry, I did not mean to
fine.
speak over you, Justice Passant, but the Facebook does have a feature called People You May Know, which anyone in this room who uses Facebook has experienced that feature, whereby it may recommend persons that you might want to know, and then the user has to take the step to accept that. But what's important in this case is there really is no allegation in this petition that Facebook connected this criminal trafficker with Jane Doe. I will point the court to 2 paragraphs.
Question 3 is quoting from the Texas Supreme Court in terms of its allegations, the allegations against Facebook.
Yes, and I think
and that's what we're dealing with at this point.
I understand, Your Honor, and I think what the Texas Supreme Court did was to say in the context of 230, and I will note while also repeatedly saying we're not deciding that these allegations actually state a Chapter 98 claim, what it did was say what allegations have been made under the Chapter 98 heading, and it cut and pasted them into the petition and said these are the allegations, and for purposes of 230 it decided that those allegations made statements that took that claim out from under 230. And I just, for purposes of directing your attention, the 2 paragraphs where connecting and is mentioned are at paragraph 190 on 502 of the record and paragraph 225 on 509 of the record.
All right, we'll let you have time for rebuttal. Thank you.
Thank you, Your Honor.
Good afternoon, may it please the court. I'm prepared to address the questions the court presented yesterday. I do agree with Ms. Sandell on one issue that Ford applies, but I think our reasoning why and how it applies might differ, to no surprise.
Does it make a difference for our analysis whether it's a product, service, or platform?
I don't believe it does, Your Honor, because at the end of the day, Facebook, we're holding a company liable for its acts in Texas. And it is much more than a product or a website, much more than a website in terms of it calling itself a product. So it's the defendant's contacts with the state that are relevant. So I believe that Mr. Zuckerberg, who's far from a layperson, calling it a product, or their SEC filings calling it a product, indicates that's how they intended this to be used. It's manufactured, it's designed, it has all of these same words that you'd see in a typical product context. So I understand the product liability issue has been resolved for now, but the issue in terms of what is fair, what could Facebook reasonably anticipate being held in Texas for, I think it's business characterization as product. Counsel's called it a service in the trial court, and their own filings refer to it as a product, and it specifically talks about it's to provide each user with a personalized experience. It's not simply a website. So it wants Texas users so it can get Texas data to make Texas dollars by selling ads, by connecting users in Texas. I've been arguing these jurisdictional cases since Goodyear versus Brown, Daimler versus Bauman came out and changed general jurisdiction. So I've been involved with a specific jurisdiction pickup in cases as Daimler predicted would happen. Some of the cases that I've argued and briefed were cited by Ford as a reason for the Supreme Court to take it up. I've been following the arguments. I've been keeping up with it. The same type of arguments that Facebook makes, well, the senior management did something other than Texas. He doesn't say where it ever happened, and it doesn't explain exactly what it is. What we know is they have a user operations center, one of 5 in the world at the time, and that is for supporting users. That is Ford. The reliance that Facebook is trying to put on Walden specifically rejected in Ford because there was no contact. The only contact was the plaintiff being Nevada. It was a far cry from what we have here. In rejecting it, the court noted that none of our precedents suggest that only a strict causal relationship between the defendant's in-state activity and the litigation will do. As we note, our most common formulation of the rule demands that the suit arise out of or relate to. And so at the end of the day, the characterization as a product, service, online platform facilitates its business in Texas, or is its business in Texas, which is online social networking, connecting people. When someone's using it, instead of paying in dollars like you would pay for a typical product, you pay with your data. The more you use it, the more data they collect, and that's how their business model works. Now, I know counsel offered some argument today about opting in and being able to, that's a user's choice. Our petition alleges that Facebook's marketed in Texas at the relevant time, and a litany of other allegations that I'm sure the court is aware of. The only thing that Facebook negated in its declaration was that safety decisions at a high level, not the implementation of them, not whether or not the user operation team is responding to law enforcement or otherwise engaged. So none of that's been established. It didn't exist in 2012. And I know that they have taken some issue with us citing 2019 because that's what was available. But it's reasonable in the absence of a declaration from them stating otherwise that what they were doing in 2019 is similar to 2012, and without any findings of fact, conclusions of law, jurisdictional discovery in this matter, it's a fair inference to draw that those same type of activities were occurring regardless of where senior level management may have been. And to briefly, Your Honor had asked about a social media case after Ford, and I believe counsel cited Gillen. That's a 2016 case, so that's well before Ford.
But do you agree that we're limited to 2012 in our review?
For specific jurisdiction, I don't believe it's limited to 2012. I believe it's limited going into 2012. I think that there is case law that suggests that for general jurisdictions at the time of filing, and for specific jurisdiction, it's at the time the cause of action accrues. I do believe that's a fair statement but looking at any of those cases say you can go back a little bit. So we know at one point in time, Facebook was only accessible if you had a harvard.edu address in Cambridge, Massachusetts. Well, certainly then, we could only be held in a court over here. When they made the decision to extend beyond that, at first it was just to other colleges. You had to have another EDU address. So they could arguably make a claim that we only have it at the University of Oklahoma, so we could never be involved in Texas. But that's not what they did. They've reached out and they have established relationships just like Ford with Texas. And as Burger King warns, the due process clause may not readily be wielded as a territorial shield to avoid interstate obligations that have been voluntarily assumed. And because modern transportation and communications have made it much less burdensome for a party sued to defend himself in a state where he engages in economic activity, it usually will not be unfair to subject him to the burdens of litigating in another forum for disputes relating to such activity. It goes on to say that if a company is too concerned with doing business there, if Facebook's too worried about the statutory 98 claim that the Supreme Court has said we have adequately pled for purposes now, then they can structure their business to avoid jurisdiction here, or they can cease doing business altogether. That's a business decision for them to make. Instead, they have continued since the time they registered to do business in Texas in 2009 up until through 2012, when Jane Doe was contacted by a trafficker using the Facebook product in Texas. And one thing, just briefly, I know Council referenced Facebook.com. Facebook.com Inc. is the company. It offers a suite of products, if you will. It's got Facebook, Instagram, WhatsApp, I think Oculus. That's like Ford. They've got a Crown Vic, an Explorer. They're different products. But the number of cases Ford specifically talks about a hypothetical where Ford made, some car only for driving in some specific place that maybe you couldn't subject to jurisdiction if you only sold that car in Alaska. If Facebook had some product that was only for Texas users, then that would be, only for Oklahoma users, and they tried to sue in Texas, that'd be a wholly different scenario. But at the end of the day, it's a product that they offer in Texas, and the reason they do it is because they want to sell advertisements to Texas. Well, they want to get Texas users so that they can sell that data to people that want to advertise to Texas, so that they can target them. So the allegations, I believe, we've alleged Facebook marketed, provided significant support. They're the same allegations. For to answer question 2, on question 3, as it relates to I'm sorry. Before I move on, I want to backtrack 1 second. On the question about whether or not the characterization matters, there is a in Ford at page 1028. The court states that it uses this exact fact pattern: a resident plaintiff suing a global company extensively serving the state market for a vehicle for an in-state accident, as an illustration, even a paradigm example of how specific jurisdiction works. It's an example. It's a metaphor. It's not there are cases we've cited in the briefing, and I know it's not an issue in front of the court today, but where it's been applied outside of a product liability context. But here it makes sense because that's what Facebook's Texas contacts, its activities directed at the forum are. So here, Jane Doe was targeted in Texas. She was trafficked in Texas. The relevant conduct giving rise to her claim occurred in Texas. It makes sense for Texas to provide a forum for her to seek redress. This going to Ford at 1029. In other words, Ford has systematically served a market in Montana and Minnesota for the very vehicles that plaintiffs alleged malfunctioned and injured in those states. So there is a strong relationship among the defendant, the forum, and the litigation, the essential foundation of specific jurisdiction. Here, we have the product that they're putting out, the Facebook product that's used and causes injury in Texas. And so and I've sort of addressed question 4, but that because the relevant conduct occurred in Texas, there is the affiliation, the necessary affiliation. Counsel earlier referenced Walden.
Well, there is a line of cases that says that you cannot use the co-conspirators' actions as part of your jurisdictional contacts. Correct?
Correct. I don't disagree that that's what the law says, but I don't believe we're alleging that our claim is based on Facebook's purposeful contacts in Texas.
Well, let me ask you how you distinguish the Huffington Post case from the Fifth Circuit.
Well, the Huffington. May I grab it? In a Huffington Post, the court noted that there were no physical ties to Texas, that it has no office in Texas, employs no one in Texas, and owns no property in Texas. It's going to the purposeful availment, the additional contacts, the additional conduct that it shows an intent to serve the market. So I think that's why there's such a distinction, but more fundamentally.
Well, certainly Huffington Post serves the Texas market, or whatever state that was in Huffington Post, because
Sure.
it's a nationwide newspaper, right? So I mean, it tries to serve all markets.
It does, but it's a website that's merely accessible by anyone anywhere. That's not the case with Facebook, because it's an individualized experience where no two users are alike. That's in their filings, because it's an algorithmic sequence where it's constantly collecting data and changing, so that if I log in or you log in or anyone in this room logs in, we're going to have completely different experiences. So it's not, Huffington Post is merely a website. That's where merely operating a website is not enough. That goes to one of the, in Ford, footnote 4, talking about the retired man in Maine selling decoys. And I think that's more akin to Huffington Post than we have with Facebook. In closing, I'd like to thank the panel for its time today. Though having her time in court is very important to us, and it's critical that she have a place to seek redress in Texas. Facebook made the strategic decision to expand into Texas back in 2009, registering to do business as online social networking. It has marketed, provided support for that, and profited from that activity in Texas. Jane Doe's claims arise from that conduct in Texas. Facebook can hardly claim shock or surprise when faced with suit in Texas for the business it conducts in Texas. To paraphrase from Justice Gorsuch's concurrence, no one seriously can question that Facebook, seeking to do business, entered Texas through the front door. And I cannot see why, when faced with potential liability under a Texas statute like Chapter 98, it should be allowed to escape out the back. For these reasons, the trial court's decision should be affirmed.
Thank you.
Thank you.
Thank you, Your Honors. I just want to follow up on the point the court asked earlier about post-board cases involving websites and holding that the accessibility of a website is not enough. And the ones addressed in our case are the HEP case out of the Third Circuit, as well as I think it's the Pavos case involving Snap out of North Carolina. That would be in addition to the Huffington Post case that I mentioned. Plaintiff's counsel criticized Facebook's affidavit or declaration presented in this case, saying that it didn't negate that someone failed to properly apply Facebook's policies. But a Chapter 98 claim is not based on the idea that somebody dropped the ball in implementing policies. The Chapter 98 claim here, though the allegations in the petition of facts surrounding it are certainly quite thin, and we've noted in our briefing that would give that alone would give the court grounds to dismiss it, because you really can't conduct the necessary test. But leaving that aside, the allegation here is that Facebook knowingly benefited from participating in a sex trafficking venture. And so the point of the affidavit is that all we can tell is factually alleged in this petition is about policies that the company has about who can use the platform, who can communicate with whom on the platform.
Is it knowingly benefited or knowingly participated in?
So the knowingly modifies both, Your Honor, and it's an actual knowledge standard. It's knowingly benefited from participation, and this is similar, I will tell you, to a federal sex trafficking statute, and so there's a good bit of case law around what the knowingly means and what it modifies. But the point of the declaration in this case is that the policy making, which seems to be the only thing that is alleged in terms of what is alleged to have allowed this criminal trafficker to connect with Jane Doe, that was the responsibility of senior leadership located outside of Texas. I also want to point out, plaintiff's counsel says that the actionable conduct happened here in Texas, but they don't point to anything. And it's easy enough to say that, but the burden on the plaintiff is to plead a tort in Texas if that is what the argument is. I also want to touch back on the connecting question and just point out that, as I mentioned, we do not read this petition and have not from the get-go as actually alleging that Facebook had anything to do with the connection that was formed on the platform between this criminal trafficker and Jane Doe. But I will also point out to the court that in the record at 1102 is the 2012 10K of Facebook, and that 10K demonstrates that Facebook did not have any data centers in Texas in 2012. Now, determining where any part of a Facebook user's experience on the platform physically occurs is something I'm not sure you can even do, because internet information passes across the internet in an automated process, and frankly may involve different parts of the process happening at lots of different data centers. But the overarching point here for this case is that there wasn't a data center in Texas in 2012. Again, that's at 1102 of the record.
But you did not deny that you had offices in Texas.
Absolutely, we had an office in Texas. It's an Austin office. It's pointed to in the plaintiff's briefing, and we do not deny that we had an office. The final footnote in the plaintiff's supplemental brief in this case notes that that office was opened in 2010 with 7 people. So hardly a major center of Facebook's operations at that time. We all know that Facebook has a much larger presence in Austin now, but in 2012 it was a very small presence. And the point is that the work being done in that office, there's nothing in the allegations or the proof before this court that demonstrates that anyone in that office had anything to do with setting or any responsibility for setting the corporate policies that the plaintiff complains about as allowing this criminal trafficker to contact her.
What case would you rely upon to require that the corporate policies be the definitive factor?
I think that's from the statute itself. One must engage in an overt act. So there has to be knowingly benefiting from an overt act designed to. I will be honest with you, frankly, I don't think that the corporate policies that are the setting of the corporate policies complained of in this case makes a Chapter 98 claim. I don't think that Facebook's decision about what age people can be to use the platform is an overt act in furtherance of a sex trafficking venture under that statute. But we have to deal with what the allegations are in the petition if the court chooses to conduct that analysis. Again, under Urban versus Barker from this court, the fact that the petition really doesn't allege an overt act by Facebook that fits the Chapter 98 allegation is grounds to dismiss the claim for lack of personal
It seemed
jurisdiction.
like the Supreme Court found several overt acts alleged against Facebook.
It's very nuanced, Your Honor, I will give you that, but they repeatedly state we are not determining.
Well, but that's not our job either at this point. We're just supposed to look at the allegations.
Understood, Your Honor. And so, like I said, if you choose to undertake the analysis, then that's what the status is in this record with respect to the Austin office. Very small, and no one there doing anything around the setting of corporate policy.
Were the corporate policies listed on the Facebook webpage in 2012?
The terms of, in terms of what age were they listed on the Facebook website in 2012? I do not know the answer to that question, Your Honor. I'm not sure it's in the record, but I'd be happy to follow up with a letter brief if you'd like. My assumption is that they are, because Facebook does put a great number of its policies on its platform. So my guess is they absolutely are, but I'd rather get a definitive answer for Your Honor rather
Okay,
than to.
I appreciate that, thank you.
Absolutely. And I see that my time has expired. May I make just one more point?
Yes?
So, counsel for plaintiffs said regarding the Huffington Post case, and they've said this with regard to a number of cases in their briefing, that some of these cases saying a website does not count for purposeful contact, they didn't have any other contacts. Well, the fact that they didn't have any other contacts doesn't transform Facebook's additional contacts here into things that are related to the Chapter 98 claim. What the plaintiffs said is, you know what? Facebook can make a choice. It wants to do a business in Texas or it doesn't. And if it's going to do business in Texas, then it gets sued here. That was the argument just made to this court. But that is general jurisdiction, and if this court were to undertake to determine that specific jurisdiction exists on the facts before it, you would essentially be adopting a general jurisdiction standard, which the Supreme Court has said you cannot do. Thank you, Your Honors.
Thank you. We apologize for misspelling your name on our
I didn't even
on our docket sheet. Thank you very much for your arguments. The case of Facebook versus Jane Doe is submitted, and we are excused.
All rise.